Education, Adam Akers, audio-video specialist, and all of the culinary and media students from the Mays Career Academy. We certainly enjoyed the cuisine for our dinner, and you'll also experience that at our reception. I also want to thank our securities teams and our medical folks who are on hand just in case of an emergency. Thank you to the Wichita and Mays Police Departments, the Sedgwick County Sheriff's Department, Sedgwick County Emergency Services, and the Kansas Highway Patrol. And I also want to thank Chief Judge Jeff Gehring and all of the judges and staff who are here tonight and has been so helpful throughout this process. We appreciate your hard work you put in to the judicial branch every day, but we are particularly grateful for your help in planning and carrying out this visit. Next, I want to introduce our honorary bailiff for the evening, Ellen House. Welcome, Ms. House. Ellen worked for the 18th Judicial District for 29 years. She started as an accountant back in 1992 and became court administrator for the 18th in 2002, a position she served until her retirement in 2021. And you think about everything she encountered between those years. She started integrating personal computer networks into our court work dealing really early on. And then she ended her career having to struggle and deal with like all of us did with COVID. And I know that was very challenging. So thank you for all of that. Through it all, she worked with judges, court staff, court users, and the entire community to make your courts work better. Welcome, Ellen, and we are honored to have you here tonight to get us started. Now I want to introduce my colleagues on the bench and give you a little context for the presentation you are about to see and hear tonight. As I previously mentioned, Chief Justice Lukert cannot be here tonight. She has served on our court since 2002 and has served as our Chief Justice since 2020, and she grew up in Goodland, Kansas. I am Justice Eric Rosen. I'm next in seniority, which is why I'm doing this task tonight. I have served on the court since 2005, and I'm from Topeka. On my right is we have Justice Dan Biles. Justice Biles has served on our court since 2009. He hails from this area of the state and is from El Dorado. On my left, we kind of go back and forth because that's how the seniority order works. We have Justice Caleb Stegall. Justice Stegall was appointed to our court in 2014, and he grew up in Lawrence. Next, we have Justice K.J. Wall. Justice Wall was appointed to the court in 2020 and is from Western Kansas. He grew up in Scott City. And next, we have Justice Melissa Standridge. Justice Standridge joined the court in 2020 as well, and she was also raised in Lawrence. And our newest justice, who again is not with us tonight, is Larkin Walsh. Justice Walsh was sworn into our court just this last September, and she is also from the Kansas City area. And I hope, as you can see as I've introduced my colleagues, we have justices from all over the state, all of whom have served for different lengths of time and bring different life perspectives. It's those differing perspectives and experiences that help us as we approach cases like the one you're about to see tonight. Our court is an appellate court, which means that we are usually not the first court to look at any given case. We don't accept evidence or hear new testimony from witnesses like you typically see depicted in movies or what you've witnessed in the community or see on TV. Our job is to review the work of trial courts to ensure they didn't make any legal errors that impacts the outcome of a case. When a litigant thinks that a trial court made a mistake, they can appeal to the Court of Appeals, which ultimately can come to our court or directly to our court, depending on the type of case. Once the case is started, the litigant files a written argument, which we call a brief, about why the trial court got it wrong. The other side gets to file a brief in response, and once the briefs are all filed, the case is set for oral argument, which is what you're about to witness and experience here tonight. At an oral argument, typically, most usually, each party has 15 minutes to tell us why their side should win. During that 15 minutes, justices can also ask questions to each side's position, which I imagine you'll witness tonight also. Once arguments are over, my fellow justices and I will conference the case, which means we meet together and will discuss amongst ourselves who should prevail and why. Once a majority of the court agrees on those decisions, one justice will be assigned to write a written opinion that lets the parties and the public know the outcome of the case. If a justice is not in agreement with the majority, he or she can write a concurrence or write a dissent to let the party and the public know why they disagree. That process can take several months, and you can find all of our decisions once they're filed on our website at kscourts.gov. Anyway, with that, I will now ask Mr. Doug Shima, clerk of the appellate court, to call this evening's docket.
Thank you, Your Honor. May it please the court. The 6:30 p.m. docket for Wednesday, November 5th, 2025 consists of one case. Appeal number 127122, Paul L. Savage and Gail Williams, trustees of the Savage Harrington Family Trust, Paul L. Savage and Paula J. Savage versus Amal Timsah, Sedgwick County. Counsel for the appellant has requested 2 minutes for rebuttal. Counsel will now enter their appearances.
My name is Jerry Bogle. I'm an attorney from Wichita. I represent the appellant, who is Amal Timsah, who is also present.
Patrick Hughes from the Adams Jones Law Firm in Wichita. I represent the plaintiffs and appellees in this case. That would be Paul L. Savage and Gail Williams, trustees of the Savage Harrington Family Trust, Paul L. Savage and Paula J. Savage.
Chief, we're ready to proceed.
Thank you, Mr. Shima. Once you're settled, I will ask counsel to approach and begin your oral argument. And I do note that you reserve 2 minutes. Okay, you can approach. Thank you.
Justices, counselor, ladies and gentlemen, as you justices are aware, we are looking at a fee switching case today. The American rule is that the loser of the case, but for any exceptions, does not pay the attorney's fees for the winner. The origin of the title, excuse me, can you hear me? Yeah, sorry.
No, that's all right. Go ahead.
It's called the American rule because we got our law basically and originally from England, and in England they have the ability to, in each case, have the loser pay the fees for the winner. It's not mandatory, but it is available in every case. So they have the ability for an exception. In this case. The American rule provides that the loser will not pay the winner except for a statutory authorization or an agreement of the parties by contract. That's the general rule. And in all of the cases that we've talked about, that we'll talk about in this case today, the general rule will be stated. And then we're trying to discern today whether there should be an exception in the instance of a quiet title action where the party involved as a loser is involved in some wrongdoing in relationship to the clouding of title, which created the need for a quiet title.
I have a question. So if attorney's fees can never be recovered without statute, how do we treat our own cases like, I'm not sure how to pronounce this, Cubbin and Reese, that allowed them as damages?
I didn't understand the labels you gave me.
Okay, so it's your position that attorney's fees under the American rule, cannot be recovered without statute or agreement of the parties.
Correct.
Okay. But we have case law from 1916 that allows that. So do you want us to overrule those? Do you want us to distinguish those? Do you...
I wish to speak to that, Your Honor. That was where I wanted to go.
Oh,
because
great.
in 1916, the Cuban case, Campbell versus Cuban, is the alleged exception as to quiet title actions. And I say alleged because I'm going to argue that it is not authority as an exception to the general rule. And the reason I say that is because there was a first suit filed, and in that case, the court found that there was a fraudulent deed involved. And then a second suit was filed to recover attorney's fees. And the precise, this case is 2.5 pages long. It's not much to discern what they say that case means. In that second case, the plaintiff sued for expenses in the quiet title, including attorney's fees and exemplary damages. Then there's a discussion about the defense on that case was res judicata and splitting the causes of action. And the court concluded that neither of those were an applicable defense to the petition. But the court found in that case and this is, I'm paraphrasing, but it found that res judicata only applied to the issue of fraud. So that case essentially, in the second case, became a fraud case. And when the court ruled in this case, and as I say, it's a very short case, it ruled that the plaintiff was entitled to recover any expenses and then reversed it and remanded it. Any expenses is not the specific authorization for switching attorney's fees that is discussed in several cases in the state of Kansas. It has to be specific in order to be clear. And I want to say two more things. Number one, the Court of Appeals quoted that last sentence that I said, entitled to recover any expenses. And then in the next case that's relevant in this subject is the Campbell versus Reese case. And in that case, they made a finding that they said the court found plaintiff clearly was entitled to attorney's fees and exemplary damages. That's not accurate. I've read that case carefully, the Cuban case. It does not say that. It certainly doesn't talk about exemplary damages at all being entered, and doesn't make any kind of specific finding as to attorney's fees. And that, in my opinion, it takes away the ability for Cuban in 1916 to be held as case law authority for the conclusion that was presented in the trial court and it was presented in the Court of Appeals. It doesn't say that.
Okay, so it would be appellate's position that there's no need to overrule it because they're distinguishable?
Correct. And then the next case that came, well, let me talk about the Reese case for a minute. In the Reese case, it was a typographical error which clouded the title to the property, done by a title company. At one point in the Reese case, the court says the court is bound to do equity, and there aren't any cases in the state of Kansas that conclude that equity is a basis for fee switching. And I'll refer to several cases and then come back. There are 4 cases cited in the Dietz case, which is the next case I'll get to. The Unruh case, the Idbeast case, the Snyder case, and the Straden case. All of those are Supreme Court cases, not Court of Appeals. All of them make the ruling that you cannot switch fees based on an equitable position. So regardless of the equity in this case, regardless of those are the four Supreme cases. The first one's 2007, 2008, 2009, and 2014, all rather recent cases. When the Reese case talked about the Cuban case, it talked about the fact that Cuban apparently made an exception to the American rule regarding quiet title. And then it said that we are constrained to follow it. So if the Cuban case was good authority, then that's what they did. They concluded that that Cuban was in fact a case that they could be relied upon to make this decision. And then the Reese case is the 1922 case. And then we have a large period of time. And then in 2016, we have the Dietz case. And the Dietz case is the only case that has been cited among those that have been presented in the different briefs that has to do with a real analysis of this issue. And that case that was two lawsuits also. In the first case, they concluded that the title had been clouded and that the quiet title should be removed from the case, and that property should go back into the decedent's estate. In the second case, they granted attorney's fees, and in the trial court, and then the issue then becomes: is there an exception to the American rule? The court broke this down into three categories. They concluded, number one, that the basis that the trial court used for an exception was a misquotation of an arbitration clause, and that wasn't going to create an exception. Number two, they concluded that the Kansas Supreme Court, and it recites in the case the four cases I just recited to you, and they thirdly made the decision, and this is again an analysis of the Cuban case. They concluded that the Cuban case was not really an exception to the American rule, that it was likely referencing a statute as they read the case that was presented. And then in a second paragraph, they recited that it was more likely that there was a statute involved that permitted the fees to be granted in the Cuban case, more likely than creating an exception. So the Dietz case is agreeing with me that the Cuban case really is not an exception, doesn't need to be overruled, and doesn't need.
And Dietz is a Court of Appeals case?
Pardon me?
Is Dietz a Court of Appeals case?
Dietz is a Court of Appeals case, but it cites the four Supreme Court cases.
No, yes.
And therefore, my conclusion is that there is no authority in the state of Kansas, no case law authority for an exception to the rule, American rule, in relationship to quiet title cases. And so all the court needs to do is continue to follow the Supreme Court cases that it has previously issued.
Would you agree that there is a difference between costs, an award of costs, and legal damages?
You put the word legal in front of that statement. I understand that the Court of Appeals wanted to make this differentiation between damages and.
I'm not so concerned about what has been said in the case law. I just want to talk about what legal doctrine should apply. As I understand it, legal damages are not an equitable remedy and are not necessarily related to the expenses of litigating a case. We're talking about, for example, compensatory damages. When a bad actor causes somebody injury or damages, under the law, they have a right to be made whole. That's damages. I guess my question to you is, let's just say there's a bad actor that hacks into a business's network and causes a number of damages. And that business hires IT specialists to get them back up and running. Certainly, the costs of those IT services would be recoverable as legal damages. Would you agree?
Not if it is trying to create a fee-switching relationship.
Well, that's not what I asked, though. I'm just curious whether those types of services to mitigate damages and to put yourself back in the position you were before tortious conduct injured you is typically recoverable under Kansas law.
No, Your Honor, I don't agree, and there are several cases. The first case is a 1912 case, Evans versus Insurance Co., and it says even when fraud and malicious conduct is involved. That's an early case. Nevertheless, there are, let me find the citations. The Nicholson versus Fawley, F-A-W-L-E-Y, 1922 case. That case, again, says even when fraud is involved. So regardless of the conduct of the losing party, that has not been created as an exception to the American rule.
So you say the American rule applies not just to a determination of an award of costs tied to a litigation, but even to your ability to recover damages.
I don't agree that those damages are anything but cost by definition of the statute. When the statute says you may recover cost, then you go back into the statutes and you see the limitations that are included in it. And KSA 592214 is the straighter case, I think it is. And in that's a probate case. It interprets 591504 and 2214. And in that case, the argument was it's only equitable, and as a matter of fact, the language about equitable is in that statute. Nevertheless, the court decided in that rather recent case that costs do not include attorney's fees and expenses do not include attorney's fees, even if it is not equitable. And in that instance, referred the court back to 1504 to determine whether attorney's fees would be available to the winner. But even if they had been available, they wouldn't have come from the other side. It wouldn't be a fee switch. It would be attorney's fees out of the estate. Thank you.
Just colleagues, any other questions? Thank you.
May it please the court, this case could be resolved simply and cleanly by the strict enforcement of Kansas Supreme Court Rule 6.01A5. I won't belabor that point, but I will mention that the rule requires that an appellant identify where an issue was raised below or explain why it can be considered for the first time on appeal. And that was not done in this case. The court is,
if we're going to be sticklers on the rule, you had objected to this issue even being decided by the Court of Appeals. They decided it anyway. If they decided it contrary to our rule, then they erred, or that the court erred. And isn't it upon you, under our rules, to raise that error in the petition for review process?
no, because the only issue that the court was asked to consider by the appellant here is the issue of the application of the American rule. The issue, that issue was not preserved. I think this court has the ability to say the rule applies at every level, that the appellant's duty is to satisfy that rule.
And I'm just saying that each attorney's got to, when the issue's coming up from the Court of Appeals, each attorney has got an obligation to challenge decisions made by the Court of Appeals that it thinks were wrong. And you think it going ahead and deciding this issue, even though it hadn't been properly raised before,
And if my
was
objection,
wrong. So I'm just saying, aren't you supposed to raise your hand and say this is an error in the process of cross-petition for review?
in fact, I raised the issue in response to the petition for review, but you're correct. I did not raise it as a cross petition.
And that's my
And so
point.
if that's a problem, then what we do is we look at the merits of the case. And I think the merits of the case, here there are two, this can be resolved by really looking at getting a clear understanding of two things. Number one, what the district court did and why it did it. And number two, what the American rule is and what it is not. The result of that examination is the following conclusion: that a plaintiff is entitled to recover damages that are approximately caused by a tortfeasor. And the tortfeasor is not immunized from that liability by the American rule. That's because the American rule is about who, as a default matter, pays the cost of litigating a claim. It's not about whether a defendant must pay for the harm she caused when that harm happens to take the form of litigation expenses.
Counsel,
Yes.
I want to explore that very idea. Can you think of any context in which there's a civil case for damages in which attorney's fees could not be characterized as damages as you've just characterized them?
Yes, and in most civil cases that's true, because what I'm not claiming.
Well, can you be precise and
Sure.
share those examples with me?
Okay, so let me start by going the opposite direction. Where do we see in civil cases that damages include attorney fees? We see that in malicious prosecution cases, because what happens is you can recover the cost of having defended the suit in the malicious prosecution case, in the next case. What you can't recover is the cost of bringing the malicious prosecution action itself, because that's where the American rule is applied. It's applying to the cost of the litigation, not to the damage caused by the tortious conduct.
Well, let's just take an ordinary slip and fall.
Yes. In an ordinary slip and fall case, it's not, your attorney fees aren't damaging.
Well, but my question is, why couldn't an enterprising plaintiff's attorney characterize the cost of litigation in the exact same manner that the district court here characterized the cost of this litigation? In other words, but for the tortfeasor's bad act by not putting out de-icer or whatever, I wouldn't have fallen and hurt myself. Medical bills, that's damages, but I also wouldn't have had to. Now, I understand that contingency fee arrangements often take care of this, but let's say somebody had paid hourly. Isn't that just exactly the same kind of but-for causation?
No, and the important thing is that we have a quiet title action and we have a slander of title claim. We have an independent tort of slander of title. We have a quiet title action that's needed to remedy the injury. Now, what the court did here was not to grant fees for the cost of the slander of title. It asked me to submit an affidavit for fees. In that affidavit, we explicitly excluded those fees which were attributable to the slander of title, to pursuing the slander of title claim. Why? Because that's what the American rule is covering. It's saying that can't be shifted, but that's not the same thing as what are the damages from the underlying tort. When somebody causes injury by their wrongful conduct, what do we say as a court? We say that the plaintiff is entitled to recover those damages. We don't.
And I understand there, I'll just try one more time. Help me distinguish what you are claiming as damages in this case from the damages that might be claimed in another tort case for attorney's costs. I mean, in other words, if I hadn't slipped and fallen and had to go hire an attorney and pay that attorney, all of that's your fault. You should have to pay for it all.
The distinguishing feature is this. In that case, you're talking about what would be the equivalent of the fees for bringing the slander of title action. I want my fees for the tort you committed, for suing you for the tort. But that's not the fees that are at issue in this case. The issue in this case are the fees for correcting the injury from the slander of title. Once that title is slandered, The injury from that.
So are you saying that the actual work that was billed was not work in conjunction with this litigation?
I'm saying that it was, there were two claims in the litigation. There was a quiet title claim, there was a slander of title claim. What the court did was separate out what I submitted and what the court ordered then for the fees were the fees minus the entries that related simply to the slander of title claim. Now, whether that's the right formula for damages or not isn't what the issue is here. The challenge is not the question of whether the court calculated it right.
But you are talking about fees that went to the litigation. You're not talking about separate fees that, oh, my lawyer had to go out and file this paperwork with this government agency or what have you.
No, the nature of a quiet title action is, of course, it's going to be in the court.
Right, okay.
So, yes, it's in the same case, and it was a matter of separating out entry claim by claim in order to quantify what the damage was from the tort. That damage being in the form of, I now have to correct this injury. If somebody had come on my property and they hit a tree on my property, and to recover the value of that, I need to put in a new tree. I get to be compensated for what it cost to recover that from that injury. Here, the way that's done is a quiet title action. And so the cost of that quiet title action is the injury from slander of title. And that's why the restatement, that's why the many cases that I cited from other states allow the recovery of the attorney fees for the cost of quieting title as damages from the slander of title action. Because what we're trying to do is we're trying to make sure that there's no reason to immunize a defendant who has been malicious from liability for the loss they cause merely because the form of that loss happens to be attorney fees rather than calling a tree service. There's nothing about attorney fees that would justify imposing that limitation that no other plaintiff has simply because of the form in which the injury ends up being felt by the plaintiff. And so my point is that is the nature of what happens in a quiet title case with slander of title. It's the nature of what happens in malicious prosecution cases as well. We can trace the rule there back to 1901. Also third-party litigation cases. So we have cases where because of a tort you commit to me, I end up in litigation with a third party. I incur attorney fees. I get to recover those fees as damages for the tort you committed against me. We can trace that rule back to 1901 to the First National Bank of Hutchinson versus Williams case. And that case relied on the following thinking. Quote, if a person's property is taken, injured, or put in jeopardy by another's neglective duty imposed by contract or by his wrongful act, any necessary expense incurred for its recovery, repair, or protection is an element of the injury. It is often the legal duty of the injured party to incur such expense to prevent or limit damages, and if it's judicious and made in good faith, it is recoverable. Nearly 100 years later, this court in Hawkinson versus Bennett in 1998 had the same words that it used. And focusing on the relevant words, it wrote, if one's property is injured or put in jeopardy by another's wrongful act, any necessary expense incurred for its recovery, repair, or protection is an element of the injury. If it is judicious and made in good faith, it is recoverable. The essence of this rule, the substance of this third-party litigation rule, and the same principle that we see in malicious prosecution cases is that the fact that damages take the form of attorney fees doesn't preclude a plaintiff from recovering those damages. What the plaintiff can't do is recover the cost of prosecuting the slander of title action itself.
Okay, so let me just slow things down a little bit. So where are you saying in Kansas law does the court have the power to award damages? So does it come from statute or common law in a quiet title action?
So, well, in a quiet title action, it's not about damages. It's about establishing title. But in the slander of title action, the court, by common law, as in any tort case, has the authority to award damages. The legislature can limit that authority, and we think about maybe the workers' comp situation as being that kind of a situation, where the default rule...
So is it statutory or common law?
It's common law.
It's common law.
It's common law.
Okay, and then, and so what justifies that? So What justifies this narrow exception that we have here in the common law?
It's not an exception. It is a rule of causation. The rule is when I have a loss that is an injury that is caused in fact, approximately caused by wrongful conduct of somebody toward me, that's damages I get to recover. That's not an exception to anything. The problem is the mischaracterization of the American rule. What is the American rule really? Well, it's really, the answer to that is found in its name. It's called the American rule because it's not the English rule. The English rule is a default rule that allows for the switching of fees to the prevailing party, whether that party is the plaintiff or whether that party is the defendant.
Okay, okay, I understand that. So let me just, I'm going to say that as our acting Chief Justice said, Justice Walsh is participating, so she is at home, so she doesn't make all of us sick, and she is submitting some questions for me to ask. And so she does have a fact question for you. Did your client seek anything other than attorney's fees as damages? What about the cost of removing the pile of broken asphalt that Mr. Timsah placed on the driveway?
So what we sought was injunctive relief.
Right.
We sought quiet title and we sought the attorney fees as damages. We hadn't incurred the cost to remove the asphalt because we didn't have, that was part of what we were seeking authority to do. And so we did not go back and say, we did not present an estimate for that cost. We didn't think it was significant enough to do that. So we didn't ask for that cost. What we asked for was the determination that we in fact had the ability to do that, the right to do that.
Okay, thank you.
In looking at common law and Kansas law specifically, what's your best case?
My best case is probably Hawkinson versus Bennett, which is that 1998 case, 265 Can, 564, because what it stands for is this principle that if I incur expense, and the fact that my loss from a tort is in the form of remedying it by hiring an attorney, I'm still entitled to recover that loss from the tort. So I think that may be the best case for that proposition. So when we're looking at the American rule, what we're seeing is...
Just a second, counsel. I'm looking at your brief, and this sounds a little weird. So I'm not sure is that case cited?
That case is not cited in the brief. Because before the Court of Appeals, the question was, what has this court done in the past? And the Kubin case seemed to be the clearest indication of that. But now we're in a situation where you can do what you want to do. And so what has happened in the past is not really that critical to the question. What's critical to the question is, what's the underlying policy here? And the underlying policy is to say, people who are injured by tortfeasors get to recover that injury regardless of what form it takes, as long as it's quantifiable. And the American rule isn't about taking away that right. It's about saying we're not going to be like England and say winner gets to have their attorney fees paid because they won. This simply is not the realm in which the American rule is operating. It's the realm in which the rule of causation, of proximate cause, and cause in fact is operating, and the question of how we quantify damages. So that is why I think that the way of looking at it as an exception to the American rule really is misleading. It's not an exception to the rule. The American rule is acting in a different realm than the rule of what your remedy is when somebody commits a tort that causes you an injury. And when the nature of fixing that injury or remediating it here we had an injury to the marketability of title. Now, I couldn't sue for the fact that I can't sell the property because a court would have told me, you have to mitigate that. How do I mitigate that? By removing the cloud. How do I remove the cloud? By title action. That is the mechanism.
Are you saying that, it strikes me that your argument is essentially that if we were to analogize this case to a physical injury that requires a hospitalization, the doctors treating the injury is the remedial action. And your argument here is, look, it's the lawyers who are the doctors in this case.
It's true.
The lawyers are the ones that have to come in and do this take this remedial step because that's the only manner in which this particular injury can be remediated.
And we see the exact same
Well,
thing.
just first, am I getting that correct?
You are getting that correct.
Okay.
And it's the exact same thing that underlies malicious prosecution.
And that's the reason why you can articulate these quote-unquote damages as damages without swallowing the American rule, which was sort of the impetus of my earlier question.
That's exactly right. That is the distinction that I'm trying to draw. And we see that as something that's actually established in the law, because that's what that third-party litigation rule is about. That's what malicious prosecution law is about, is I can recover the cost of having to defend a case that I had to hire a lawyer to defend because you maliciously prosecuted me. And the question came up in I think it was the Harder case in front of the Court of Appeals. It doesn't really matter because, again, it's a Court of Appeals decision, but basically they said it shouldn't make any difference whether you're seeking those damages for that injury in the same case or in a later case. The nature of it is if you're seeking damages from the tort, as opposed to the cost of bringing the tort action, then those are damages from the tort, whether they're attorney fees or some other kind of damage. And that's the principle that underlies this case. And so kind of putting it in the words that this court used in the Hawkinson case, when the Savage's property was injured or put in jeopardy by Ms. Timsah's wrongful act, any necessary expense incurred for its repair, recovery, or protection, including attorney fees, is an element of injury and is recoverable. And that's why the court did what it did, and it's why the American rule isn't something that stands in conflict with that, because it's dealing with fee shifting. We're not dealing with fee shifting, we're dealing with the measure of damages for a tort.
Just a quick question of what the district court did to award the $33,000 in damages. You mentioned that was separated, that there was a separate assessment of attorney's fees. I didn't see where the district court separated the fees necessary.
Right. So what we saw, I think what the record
How
shows.
did that work? Because I just don't see, typically there has to be, attorney's fees are awarded based upon what's put before them. Are they reasonable and exactly what they're for? And I didn't see that calculation made anywhere.
And I think that that's a good observation, and there's something a little bit problematic about it, but this is one of those issues that was abandoned by the appellant. But let me tell you what happened, is the court said...
Can you abandon the reasonableness of attorney fees?
You can abandon whether the calculation of your damages was correct or not. But what happened here is that the court said, well, I agree that the attorney fees are damages for this. And what I want you to do, Mr. Hughes, is prepare an affidavit for me of those fees, and I want you to send that to me. And I want you we're not going to, I just want you to send that to me, and then we'll incorporate what I think is a reasonable fee in the journal entry. So I send the affidavit, I copy the defendant on this, and the court incorporates my number being the one that's calculated by withdrawing the entries that deal with the slander of title.
I didn't see that.
Exactly, and here's the problem. This is why a procedural ground might be the way to handle this. What the record on appeal shows is that the district court ordered an affidavit about attorney fees. It doesn't show what happens after that.
Right.
And the duty to designate a record sufficient for this court's review is on the appellant. And the appellant could have asked for supplementing the record in order to establish what the district court did in that regard. It didn't do that. And so there's a significant question of whether this court really can review this issue, not knowing from the record whether the fees here, which the district court called damages, how they were computed.
Any other questions, colleagues?
Thank you.
Thank you. You reserve 2 minutes.
Your Honor, I'll first speak to the last question that you raised about you didn't see a calculation. The court did ask Counselor to submit his time, and then went ahead and said, and it shall not be part of the record. I raised that issue in the appeal and should have gotten a new trial out of it. I thought I didn't have a number to object to, so it ultimately doesn't get, no one gets to see the calculation. I would like to
Counsel, I'm going to jump in and just give you an opportunity. You heard my exchange probably with your opposing counsel.
I did.
I wanted to give you a chance to respond, and I'm interested in your response to this notion that the only way to remediate this particular tort, slander of title, is to file a legal action.
Your Honor, I thought your first comments about where does this end? At what point do you discern something isn't damages? The attorney's fees in every case are horrible, are horrible damages for the winner as well as the loser.
Right, and as I was discussing with your opposing counsel, that very idea, I understood the argument to be, and I think I got clarification that this is the argument, is that in certain torts, in most torts, the damage is remediated by, hiring the IT staff to fix the hacking, or going to the hospital and getting the doctor to set your broken arm, or what have you. And the argument is, in this particular unique kind of tort, it's the lawyers who are the doctors or the IT staff or what have you. That's what I wanted to hear your response to that.
I don't see where it ever ends. And there is a case, and I can't give you the quote at the moment, but where the title company made a mistake. It was misdescription. The case was filed. The title company agreed, and they agreed to default judgment being entered against them. And it resolved because they resolved it. They didn't have to go through a trial to reach that conclusion. But I still find that I don't see the difference in a negligence case. I certainly don't see the difference in a strict liability case where you have conversion and you don't have to have fault or intent to be at wrong. Nevertheless, you have liability against you because of the strict liability nature of it. There's no ability for me to discern how that argument that's being made doesn't apply in every case. The Court of Appeals in their decision talked about damages, talked about the prevailing party versus damages, talked about the nuance not being appreciated, and talked about the nuance not being appreciated in the 4 Supreme Court cases, 2007, 8, 9, and 14. There was no authority cited in the Court of Appeals as to how they came up with the application of these theories was proper. What they did in effect was they contradicted the decisions in those subsequent repeated and recent cases. They looked over the decisions in those cases, which are quite clear, including the Unruh case that Judge Rosen wrote, and they decided that they wouldn't follow the rules of the Supreme Court in those cases. But they didn't cite any cases that supported their nuanced theory. And one more thing, and I'll stop, and that is the position of the court, and this is the Snyder case, and it cites that as long as the Supreme Court rule is clear, the Court of Appeals has to follow it, and they didn't do it. They ignored the clear finding, and the only exception to not following is if there has been a direction of departure from a rule, in which event the Court of Appeals could pick up that departure and move forward for it. But short of that, there's no authority of the court to overlook the Supreme Court decisions.
So, would you agree that adopting your position would be, and we haven't adopted the restatement second of tort 633, but adopting your position would be inconsistent with the restatement and the majority of states, correct?
I agree that the other states, and they have all worked on the basis that we have the ability under our equitable powers to do it. Kansas has not permitted that exception.
Thank you.
So I'm not arguing that it's not inequitable in almost every case for a winner to have to pay his own fees, but that's what we're talking about. Thank you very much.
Thank you. Any other questions, colleagues? Thank you very much for your arguments here this morning, or not this morning, this evening. I'm used to saying this morning because that's when we typically meet, but this evening. And before I adjourn court, I want to invite everyone here, including counsel, to join us for a reception in the lunchroom area, which is right outside the auditorium. So we can meet and talk, and you can ask us some questions about our court, obviously not about the case, and we look forward to interacting with anyone who would like to come, and you can enjoy some of the fine cuisine from our people from the Mays Academy. So we welcome you to join us for a reception. And with that, court is adjourned.
All rise.
Jeff.